Yes, sir.
Assigning that you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Are there any such motions?
No, Judge.
Then to the offense, how do you? All right, Norma, on this one. I'm gonna need a PSI date for us to come back on. Okay.
I doubt I have anything on that, Judge. That should be sufficient.
All right. We're at the 12-week mark now?
Out of custody, Judge.
Okay. All right, the court is calling 2025 CR 014986, State versus Tyler Ross Shipman. Can I have parties announce?
Brandon Prater for the state.
Ashley Morgan on behalf of Mr. Shipman.
And are you Mr. Shipman?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Shipman, did you review the application? Is he applying for community supervision
Yes, ma'am.
and not deferred adjudication?
That's
Yes.
that's what I'm aware of, Judge.
All right, because I'm looking at the plea paperwork. Ah, that's correct.
Yes.
All right, thank you. I misread the plea paperwork. All right, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
We are, Judge.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with intoxication, assault with a vehicle SBI, serious bodily injury, as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand.
All right, court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right, so counsels, I'm looking at the plea bargain agreement. And you said y'all are going open on whether or not there's an affirmative finding of deadly weapon?
Did Nancy the? Oh, that is our intention, Judge.
Okay. All right, so your punishment is to be at a cap of 8 years in the prison. There's a $2,000 fine. I'll decide on whether or not there's an affirmative finding of deadly weapon. But, you know, parties can argue. Do you understand?
Yes, Your Honor.
There is an application for community supervision, and the state is silent on your application. There's to be restitution of $120 to DPS, and there's to be restitution payable to the complainant. Did you understand that to be your plea?
Yes, Your Honor.
State defense is at the plea.
That is the plea, Judge.
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Assigning that you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Are there any such motions?
No, Judge.
Then to the offense, how do you plead?
Guilty, Your Honor.
State, any evidence?
Judge, offer stays in number 1, including all attachments.
And no objection, Judge.
All right, and state, have you spoken to the complainant?
I believe we have, Judge. Yes.
And what is the complainant want in this case?
Stand by, Judge. Judge, the pleading witness is seeking.
Okay, because if it wasn't, then we probably wouldn't need the PSI. I could just do things. That's the only reason why I'm asking. But I want to assure you that at sentencing, I'm sure they'll present the information to me that the complainant wants prison time. But I can always keep an open mind, all right?
Yes, Your Honor.
All right, did you review the waiver and stipulation, maybe excuse, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. We'll come back on October 15th. So this will be for a PSI. Ms. Abrams, do a TAP evaluation as well, and a referral to felony drug court. And is there any mental health or anything else?
No, Judge, there's,
All right, we'll see you back on October 15th. At that time, I'll base my decision on your application on any evidence that's presented to me. You need to make sure that you make all of the appointments.
Yes,
So
ma'am.
normally what ends up happening, you have an appointment where you go see probation, and then they're gonna send you somewhere else on another day to do your top evaluation. So just make sure you meet all of those requirements.
Yes, Your Honor.
And state, if there's any restitution, if y'all be prepared to present that on October 15th.
yes, sir.
All right, is there anything else you need from the court?
No, Your Honor.
Thank you for addressing appropriately for court.
Thank you.
You're welcome. And are you Mr. McCoy?
Yes, Your Honor.
Thank you. All right, so we're on a motion to revoke. The state filed a motion to withdraw. And before the court signs motions to withdraw, the court wants to make sure that the issues and the motion to revoke have been addressed.
Yes, Your Honor. The defense has provided me, in my approach,
Yes.
with proof of the defendant's employment with Pioneer State Bank, as well as proof that he has maintaining residency in Fredericksburg, Texas, where he was ultimately arrested on this warrant that brings us here today. So he is employed, has residency in the state of Texas and Fredericksburg.
That is
We'll give
correct, Your
that to
Honor.
Ms. Abrams. So why wasn't he reporting for compliance hearings that the court said? And this whole thing, when y'all were here yesterday about he didn't know he was off of probation, because the last time we were here, probation stated that they did their due diligence to try to get him here for a compliance hearing. And the reason why I have compliance hearings, it's so we don't get to the point of a motion to revoke. So why were you not here for your compliance hearings?
So, Judge, it's my understanding he was unaware that it was set in court.
No, he was, because probation has it in their file, and we were here last time. He had a compliance hearing on June 16, 2022. They reached out to him. So this whole thing about he didn't know he was still on probation, I find that suspect.
You know, that was, yes, Your Honor, absolutely.
And then I didn't do anything about his not appearing, and it was recalled for June 23rd. And when those compliance hearings are set, they're set for a reason. So why were you not here?
You know,
Judge, again, it's Mr. McCoy's position that he was unaware that he needed to be in court that.
All right, so can Mr. McCoy tell me that? Or does he not want to tell me that? Because a lot of times, this is what attorneys are not aware of. Dismissals, according to the law and the code, the court doesn't have to sign those. Motions to withdraw. According to the code, court doesn't have to sign those. So am I inclined to sign it? Yeah, but I want some truth telling.
I had a prescription deal where there was COVID was happening and my probation officer reached out to me after, but never told me about a court date or anything. And so I thought it was already done. He told me that I just had some fees I had to pay and he's like, and I was really confused, but he did not reach out to me via text or phone. And I swear under oath, on my children that I never got.
Okay, here's the thing. Please don't ever swear on children.
Okay.
You know, my mom always would say, well, not my mom, my grandmother would always say, you know how sometimes people say, I do this on somebody's grave.
Yes,
My grandmother would, she was funny.
I swear on my life.
No. You know what my grandmother would always say?
Yes, ma'am.
Don't swear on your children. Don't swear on your life. Swear it on somebody you don't like. Because then if you're not telling the truth,
I can't.
then it's at least on somebody you don't like, right?
Yes, ma'am.
So now, was that so hard to tell me that?
No, I appreciate you. Thank you.
There you go. Is there anything else?
No, Your Honor. The report to the court has states that there were new offenses. There are not new offenses in Fredericksburg. We followed up with Gillespie County. The new offenses that appeared were the offenses from this charge that they entered into the database as of.
All right. And Miss Abrams?
Or, that's for the aggravated assault with deadly weapon. The possession of controlled substance with the same benzodiazepines he's been, he had trouble with in the year 2000. It's about the same, so those will be resolved.
All right. So did I sign this motion to withdraw?
Judge, there's no opposition from probation. He's been expired since 2022.
Okay. I will tell you what I've found in my time on the planet. Honesty is always the best policy, especially with me. You'll get further with being honest with me than being dishonest, okay?
Yes, ma'am. Sure.
Judge, is this terminated unset?
Yes.
Okay.
All right, thank you. You're excused. You're welcome. All right, the court is calling 2025 CR 003-110 State versus Mario Garza. Can I have parties announced?
Megan Galloway for the state.
David McLean for the defense.
And are you Mr. Garza?
Yes, ma'am.
All right, Mr. Garza, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Mario R. Garza.
All right, so Mr. Garza, Attorney McLean was appointed to represent you because you asked that a new attorney be appointed to represent you. Is that correct?
Yes, ma'am.
All right, thank you. Counsel, of course, you have 10 days to prepare. Are you waiving that time?
Yes, Your Honor, I've had an opportunity to confer with my client. We're going to waive our 10 days.
All right. Mr. Garza, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Are you the same Mario Garza who's placed on deferred adjudication in 2025 CR 003-110 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 2 on or about the 10th day of April 2026 in Bear County, Texas. The defendant Mario R. Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
And we leave the ban in our here.
No objection, Judge.
All right, do you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor. It is to deny the state's motion, continue the defendant and alter and amend his conditions for a felony drug court evaluation, holding status in abeyance and ordering the fit force and a no harmful or injurious contact with Andrea Garza.
All right, the no harm or injurious contact, I don't do that unless the complainant, because is that related to the assault?
It is that case is closed out.
It's been closed, okay.
Been dismissed, Judge, yes.
All right, so you said no harm or injurious contact with whom?
Andrea Garza.
Is that Andrea EA?
Yes.
Probation,
Yes,
Is-
Judge.
is this your recommendation as well?
Yes, Judge, the only thing is, that I would say is that if he is not accepted into felony drug court, that SATA not be held with abeyance and that he actually.
All right, this is what the court, are you asking me to follow that agreement?
Yes.
All right. Do you have gang affiliation?
No, ma'am. No, but they got me as confirmed, but I was never.
All right, this is what I'm gonna tell you. Felony drug court may not accept you. So you're probably gonna end up going to SATA. So you can either accept the agreement that y'all have come to, or either if you want, I'll grant the motion, revoke you and sentence you to 3 years in the prison.
No, we're,
We'll sit back and talk about it a little bit.
no, but, I mean, I'll go with the agreement, man.
You go to the agreement, yeah.
All right, the court will deny the motion, alter the main conditions to include a referral to felony drug court, the BIPP course, no harm for injurious contact with Andrea Garza. If not accepted in felony drug court, then SATA, and he's to remain in custody until transfer. Is there anything else you need from the court to be successful? All right, good luck to you.
Thank you, ma'am.
Have a seat, sir. Have a seat.
Thank you, Judge.
You're welcome. Thank you so much.
Hey, Put it in front of you so that you
Yeah,
do
thank
whatever
you.
you got.
See, you understand.
I understand. Working a long time.
All right, we're on the record in 2026 CR 003834, State versus Angel Gonzalez. Can I have parties announced?
Megan Galloway for the state.
David McLean for the defense.
And are you Angel Gonzalez?
Yes, ma'am.
All right, the state is asking to withdraw the motion and to address the issue that's in the motion. What are we doing?
So my understanding that the defendant is now agreeing to go to status, which is the recommendation of probation. So that is the reason that she is. Motion to withdraw.
All right, so here's the thing. You have choices in life, right? Yes, do you understand?
Yes.
All right. How old are you?
40.
All right. So there are always consequences to action. I'm willing to follow the agreement that they come to, if this is what you want to do. Otherwise, if you want, I will revoke you and sentence you to 2 years in the prison. Which do you prefer?
I'll do that.
Okay. All right, then the court will sign the motion to withdraw. And he's to remain in custody until transfer to SATA. And I'm going to ask for weekly sober support meetings upon release. Is there anything else you need from the court?
No, ma'am.
All right, good luck to you.
Come on,
Yeah,
Mr.
question.
Oh, David, can you give that to Ms. Abrams?
You bet.
Thank you. All right, so we just need to give him a jury trial date, right?
Yes, Judge.
And we were in trial. We just finished a murder. Is everybody ready to go on a murder today? Should I call a jury up? I don't think we're ready.
Judge, we have conferred on the trial date. Where is okay with September 22nd.
All right, September 22nd is when you'll be brought back for jury trial. You need to do the clothing exchange. If there's an issue with his clothing, just let the court know.
Yes, Judge.
All right, do you have any questions?
No, ma'am.
All right, we'll see you back on September 22nd for trial.
Thank you, Judge.
And is that a Monday or Tuesday?
Tuesday.
On this case, do y'all want to do jury selection on Monday or no? No, I mean, what would be easier for you all? Because then if we were to do it on a Monday, then we would start testimony on Tuesday afternoon.
Judge, I'm okay if we can do it on a Monday and start Tuesday.
State, you think your witnesses will be available on that day?
Yes.
All right, Norma, is this, the 21st is not a holiday, is it?
Not today. No, ma'am.
All right, so we'll bring you over on the 21st dressed for trial and we'll have a jury brought up at that time.
Yes, Your Honor.
Jury selection, Judge, you said?
Jury selection.
Okay, sorry.
And so, they'll have him brought up in the afternoon.
For 1:30, Judge?
Yes.
Okay, yes, Your Honor.
All right, thank you.
Thank you, Judge.
Thank you.
Thank you. All right, is Adis Hernandez here?
Not yet, Judge.
Okay. Anyone else ready?
I'm sorry, Judge. We have a bias on page 12, 3 down.
Morning, Your Honor. Early this morning.
Going great.
Good.
Is this a motion to revoke?
It is.
Have you conferred with probation?
I've conferred with the state and,
Did you confer with probation?
well, no, I haven't.
Well, yeah. Ms. Abrams is an integral part of this process. If we don't have somebody here for probation, the entire system breaks down.
So there's a number of new number ones.
Yeah, but
Judge.
Ms. Abrams,
Not afraid.
Ms. Abrams, are they afraid of you? Is that why they won't talk to you?
It's because they're awaiting indictment, Your Honor. So the state's not able to make a recommendation.
I mean, the new number ones are just a failure to identify and fraudulent possession of credit card. Where is George Abaye?
These are-
Come down, please. Good morning. I don't know why they're afraid to talk to Miss Abrams. You know, we're all professionals here. Norma, set this for a contested hearing in 20 days.
August 13th.
All right, August 13th.
Thank you, Your Honor.
That's gonna be your contested hearing.
Thank you.
Thank you. State August 13th, contested hearing on Abaye.
I hear it. And YouTube tells me everything.
You're looking great. Oh, and counsel, this is for you.
Oh, thank you. Es un silencio está puesta. ¿Escuché? ¿Me escuchaste? ¿Y me escuchaste cuando te expliqué?
All right, is he able to hear?
Yes.
All right. And we have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, we're here for sentencing. According to your plea bargaining agreement, you're charged with murder and your plea is punishment at a cap of 35 years in the prison. There's a $2,500 fine, affirmative finding of deadly weapon, no contact with Marco Moreno Vasquez, and of course, there are no applications. Are there any witnesses from either side?
No witnesses from the state, and there's just the evidence.
No witnesses. Your Honor.
All right, then the court will hear arguments. State, you're asking for a cap of 35 years?
Yes, Your Honor, and I'll reserve for rebuttal.
This time, Your Honor, I'm going to be asking that the court impose a sentence of 25 years. My client has been in custody this entire time. He is an immigrant from Honduras and he does have an immigration hold pending. If you look at his PSI, he does not have any prior history. And on the date of this offense, he felt very intimidated by his boss, who was found guilty, I believe, this week and sentenced to 40 years. He expresses to me that he is remorseful and he shouldn't have gone with his boss, but he was scared of him and scared of the consequences that he would receive at the hands of his boss. So for all these reasons, I'm asking for a sentence of 25 under the cap.
And for the record, is there any objection to the PSI or chapter evaluation?
No, Joe, I'm sorry, Your Honor, no.
Oh, no problem. All right, defense, I'm sorry, state.
Judge, we're just asking for the 35 years in prison.
All right, this is what the court is going to do. As previously stated, the court is finding you guilty. The court will sentence you to a $2,500 fine, time, and money to run concurrent. There's to be no contact with Marco Marina Vasquez. There's to be no re-entry into the United States upon serving of your sentence. And the court will sentence you to 30 years on the prison. Did you review the document? I'm sorry, and there's an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement and you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. Do you understand?
Yes.
All right. And the court did consider the dynamic of power between you and the co-defendant. All right.
Thank you.
Thank you.
Can I be excused?
Yes.
Thank you. I appreciate your accommodation.
All right. Anyone else who's completed plea bargain paper work?
Yes.